Okay, we're going to talk a little bit about the case of the shipwrecked sailors. This was a case where some sailors were shipwrecked. They were out at sea. Somehow they survived in a life raft. There were three of them. They were quite shaken by their experience, and one of them was in worse shape than the others. The individual suggested that they draw lots and the loser would be killed and eaten so that the others might have a chance to survive. The person who suggested that macabre scenario drew the worst lot, was identified as the one to be killed and eaten, and suddenly, with that as the result, had a change of heart and did not want to be killed and eaten. However, the other two apparently overpowered him anyway, killed him, and ate him. And then when I just don't even think I understand how they get through the eating part. I mean, somebody yesterday said they ate him like sushi, and I guess so. That might be one way, but I don't know, not even knives and forks. You don't even have any way to cook this person. But then they were rescued 5 days later, and ultimately they were charged with murder. So this case is based on the 1884 actual case of Regina versus Dudley and Stevens. When they were tried, an English court found both men guilty of murder and sentenced both men to death. And this is what the court said. And when I say the court says this, obviously this is what the judge wrote in the opinion. We are often forced to set up standards we cannot reach ourselves and to lay down rules which we could not ourselves satisfy. But a man has no right to declare temptation as an excuse, nor allow compassion for the criminal to change or weaken the legal definition of the crime. And then sentence them to death. So, my question is, should they even be tried for murder? That's my question. What do you think? Christian says yes. Matthew says no. Matthew, I want to address your point now that Dimitri agreed with about being on international waters. So I'm going to ask you, why do you think they were tried even though they were on international waters? Why do you think? The first answer I'm going to give to this is, what year was this case? 1884? And in 1884, I'm not sure that the law of international waters was applicable. I think there were subjects of England, because they were rescued by a boat belonging to a country. Thus, the laws of the country would apply on the boat. I like the way you're thinking, Christian, but instead of the boat, how about the fact that they were citizens of England? And while there might be laws that are not applicable on international water, that is usually about the dealings in international law between countries. So if you're a citizen of a country, the laws are still going to apply to you. And in 1884, there may not have even been any perception about the laws on international water applying or not applying. I'm thinking about these boats that go off the coast of California, and the drinking age is now 21. in California, but they go off the coast and you can drink if you're 18 and you're in international waters, so the laws don't apply. But I don't think that's really any different than if you are in a foreign country and you commit a murder. Well, the United States still has jurisdiction over you even if you're in that other country. So it's a great point about the international water and the law not applying, but laws are still going to apply to you if you're a citizen of a country. So I hope I'm answering that a little bit more clearly. But yesterday we discussed the issue of mitigation. I'm going to read your statement in a second, but I want to address the issue of mitigation. So we talked about mitigation. We talked about that yesterday. What type of arguments can Dudley and Stevens make that might mitigate their situation? So while you think about that, do not belong to any states known under the doctrine of states have the right to fishing, navigation, laying cables as well. So Matthew, what you've just described is the, so Matthew was pointing out how international waters, the high seas, do not belong to any state's jurisdiction. So if the United States wanted to lay cable that would help navigation or flight or pipelines, then Japan can't say you can't lay that cable, and an international court of law is going to say California, or I'm sorry, the United States is on the high seas. But that's very different than a citizen of the state committing a crime on the high seas. And could it be argued that to forcibly took over the boat from the guy they murdered and therefore could be considered pirates? They're considered murderers, absolutely, pirates and murderers. And the reference that Matthew gave is nation to nation. It doesn't, and Matthew, you might be confused by this word state. So notice how state is capitalized here. So state means nation. In America, we have 50 states, but this is just the jurisdiction. In Canada, they don't call them states, they call them provinces. The United States itself is a state. Germany is a state. So we have 50 states, but the term state also references the United States. Like Canada is a state with provinces. The United States is a state with states. So that is how it's determined. It was not premeditated. Holly, what a great point, right? They didn't decide, hey, when this ship gets wrecked, we're going to get on the boat and we're going to murder Brooks. Was that his name? Brooks. We're going to murder Brooks. So it wasn't premeditated in that sense. But Holly, how long does premeditation have to be before the murder is committed? When they drew the lots, they determined that they were going to kill someone. And then when Brooks said, no, don't kill me, they didn't get in a fight about that and Brooks wound up dead. The premeditation took place before the killing, even though it was not much prior. I would argue here that there was premeditation, that they determined in their minds that they would kill him and then did. So premeditation only has to be not in the heat of the moment. So maybe your point is correct, and maybe they could argue that as a mitigating circumstance that, well, we never really going to kill him until he didn't want to die, and then we just reacted. On the other hand, no, you intended to kill him. You drew the lots, he lost, and you killed him. So you're thinking like a lawyer, Holly, by trying to make arguments. And that's what's great about this is you get to make the arguments. And if you can convince the jury your argument is is stronger, you win the case. Would it technically be premeditated since they knew someone was going to die? Albert presents the conflicting argument, and Lexi agrees. And Demetrio says, could the defense with the C, like the British, because we're in English court. Demetrio, that is fantastic. Could the defense argue that Brooks died of natural causes and they ate him since he was edible? Well, they can argue whatever, but they themselves have admitted that that they killed him. So a jury is going to hear now they've changed their mind. And in mock trial, we call that impeaching the witness. So they've already given their account, and if they're changing their mind, well, they better have a reason for whether they were lying now or lying then. They were starving. Yeah, that's a really good mitigating circumstance. We thought we were going to die. We thought we were starving. So maybe it's not murder, maybe it's manslaughter because of these mitigating circumstances. But they already confessed. That's right, Holly. They shouldn't have said anything without a lawyer. Exactly, even in 1884. So let's wrap up this discussion with the following point. So this is an interesting case because soon after the verdict that they were to be hanged, Queen Victoria commuted the sentence to 6 months imprisonment. So let's talk about that word for a second, commute. You hear this in criminal cases sometimes. So what does the word commute mean? And I'm not talking about getting from point A to point B, not commuting to school, not commuting to work, commuting a sentence. So in the dictionary, you got to go down to definition number 2. Well, what does commute mean? She took pity on their poor souls. Well, they had certainly been through a lot. It means to reduce the sentence. Exactly. So she reduced the Queen of England, reduced the sentence from death to what was it? To only 6 months imprisonment, and then they were freed. So why do you think she did this? She took pity on their souls. I wonder if the person thought deliberately about what he was going to do. So do you think Queen Victoria did the right thing? Was that right? And why do you think she did that? Is the horror that they were in so significant that it doesn't justify what they did, but it makes it a whole lot less egregious or horrible, do you think? But I want to ask you to think a little bit more deeply. Why do you think Queen Victoria commuted their sentence? And Demetrio, you pointed out she took pity on their souls, and I love that phrasing. And Holly says she most likely understood the circumstances of the situation that they were in and saw that the punishment they received was too large. There's no doubt about that. No doubt about that, and that's what helped drive her. Stefania says maybe she changed the sentence due to their survival instincts and how it might have just kicked in since they weren't right. They're just trying to survive, for sure. Now, I've been asking you to think about your answer here legally. We've been having a legal conversation. I want you to shift your contemplation. I want you to shift your perspective and think politically and psychologically. And see if thinking about this politically or psychologically gives you a slightly different answer than the legal issue or the emotional issues you're giving me, which certainly are correct. They absolutely play a role. But why would a queen, the Queen of England, memento mori, coming at us with some Latin, because she knew that it would help her self-image. It would help her self-image. Love it. And why would it help her self-image, Christian? What is the queen trying to do in general? What do queens want their subjects to feel about them? They want them to be angry with them. They want them to be loyal, but how do you win loyalty? She wanted to look compassionate, wanted to be on the side of the people, respect and loyalty. So here is the lesson. This isn't a lesson about the law. This isn't a lesson about whether you think they should have been tried for murder or whether they acted appropriately or inappropriately. We are scholars. We are at the highest level of critical thinking. This is a lesson about public opinion. And sure, Queen Victoria probably felt all of those things about the mitigating circumstances and took pity on their souls. But what is the real lesson here? The people of England, they're the ones who were expressing, this might be horrible, but we can't put these two people to death. How do we know we would not have done the same thing? And so by law, the jury or the judge was required to follow the law, which was a death sentence. But the queen commuted the sentence because of public opinion, right? Public opinion. And the lesson to draw from that is, in our own country, today's situation with all sorts of things happening, look at the thing public opinion can become law, But I like your metaphor, just right to public opinion is the law. Well, and it certainly drives behavior and emotion, but look at what happened yesterday when I talked about the events of the day. We saw that the Democrats in Congress, in the House of Representatives, are passing legislation that may or may not become law. We'll talk about the whole lawmaking process that is about police reform. Now, my question is, 2 weeks ago, was that on the agenda today? Of course, it's in the general agenda, but they weren't scheduled to debate and discuss it. They weren't scheduled. It was drawn. It was pushed into the focus. It was pushed into the agenda today because public opinion pushed it there. So I think that wraps up our conversation about the shipwrecked sailors.